Everyone, hello, and thank you for attending the webinar today. I'm going to discuss the Corporate Transparency Act, which has been discussed quite a bit in recent weeks and months after being essentially, I don't want to say ignored for the first half of the year, but things have started to become more real in light of the fact that it's the fourth quarter of the year and the deadlines are coming fast. And so with that, let's talk about the Corporate Transparency Act. My name again is Leah Burton, and I'm an attorney with Steptoe & Johnson, PLLC, officing out of our firm's Plano office, although we're all over the state of Texas and all over the East Coast, Oklahoma, and Colorado. So there's been a lot of talk about the Corporate Transparency Act, and some of it has been not to say that it's been an attempt to be scary or to make people panic, but really that's what the effect of the news coverage of the CTA has had the effect of doing. And when I say CTA, that is Corporate Transparency Act is what I'm referring to. And so what we're going to do here is I'm going to break down really what the Corporate Transparency Act is, how it affects you as a board member, and the steps that you need to do as both a board member and as an HOA in order to comply with the requirements of that act. So people are wondering where the CTA came from, and because it did seem as though it came out of nowhere, but in fact, this has been in play or contemplated since 2006. So back in 2006, there was some criticism over the lack of transparency with regard to U.S. companies, meaning a company can form in the country by filing its certificate of formation or articles of incorporation with its state, and then you're just off and running as a corporation with no real oversight as to who are these individuals who are forming the companies. And so over the course of the last almost 20 years, the federal government has been kind of trying to figure out how they can monitor and somehow oversee the individuals who are forming these companies to make sure that the people that are forming the companies are on the up and up and that there aren't any criminal activities afoot. So the CTA was ultimately enacted by Congress on January 1st, 2021, but it did not go into effect until January 1 of this year. Just ignore my phone. And with that, let's continue. So what the CTA says is, it is the sense of Congress that a database about the beneficial owners of business entities, corporations, is needed to protect vital national security interest and better enable critical national security, intelligence, and law enforcement efforts to counter money laundering, the financing of terrorism, and other illicit activity. So these are some big goals that Congress has set with regard to the CTA. And as you can see, it's really all about finding the bad guys who are forming corporations in the United States with bad intentions or with the intention of trying to hide money or finance terrorism. And so it is a noble objective. Unfortunately, we in the HOA industry and board members specifically are getting caught in the crosshairs of this initiative. So Congress came to the Department of the Treasury and made this declaration about what we need in order to protect national security interests. And so what the Department of the Treasury recognized was that there are bad guys who use the fact that you can form companies in the United States as shell companies to hide their true identities in order to money launder. And that is what they are in order to finance, again, terrorism and all kinds of criminal activities. And so what the Department of the Treasury recognize is that those actions by those bad guys undermines our national security and threatens our U.S. prosperity. And so they determined that we need to do something about it. So what used to be the status quo is that a corporation, and many of you probably have a corporation that you are either a founding member of or are working for. And so again, in the old days, you would file your articles of incorporation or your certificate of formation with the Secretary of State of Texas, and then boom, you'd get your letter from the Secretary of State saying, okay, you are now a corporation in the state of Texas, and away you go. Now, you still have to file with the certificate of formation with the Secretary of State, but now you also have to file an application with FinCEN. And I'm going to tell you who FinCEN is here in just a second. FinCEN. FinCEN is the U.S. Department of the Treasury Financial Crimes Network. It has been formed by the Department of the Treasury, and it is a bureau that sole mission is to collect and analyze all the information about the founders of the companies that form in the United States so that they can then combat domestic and international money laundering, terrorist financing, and other financial crimes. Once they take in all of that data and analyze it, they're going to use that data to then issue regulations with regard to all of those companies. So who has to report to FinCEN? Reporting companies have to report to FinCEN. What is a reporting company? A reporting company is created by the filing of its certificate of formation. So a corporation that has formal corporate identity in the state of Texas is a reporting company per the CTA, unless it falls into one of the named exemptions. And on the next slide, you'll see the list of possible exemptions. As you can see, there are several. So there are some companies that do not have to file this paperwork with FinCEN. The only one that we as an HOA or you as an HOA board member could possibly fit under is the highlighted exemption, which is an entity that is exempt under the Internal Revenue Code Section 501A. To qualify for that exemption, an HOA has to be tax exempt under Section 501A of the Internal Revenue Code as an organization described in the Internal Revenue Code as a Section 501c4. Now, I am not a tax attorney. For purposes of the CTA, this is what you need to know. Unless you are a 501c4, you are going to have to report your HOA's beneficial owner information. Just because an HOA is a nonprofit does not make it tax exempt under that 501c4, which is for charitable organizations. And just because it is incorporated as a nonprofit doesn't mean it's tax exempt. So when an HOA comes to me and says, okay, do we fulfill the requirements of the tax exemption so that we don't have to report? I say to them, okay, well, show me your letter from the IRS that acknowledges that you're a 501c4. If you have that letter, that's fantastic. Then you're done. You don't have to report. I only have, out of all of my communities that I represent, I have 2 that qualify for this exemption. And really the reason why those 2 are exempt is because they sought the exemption 40 years ago. So the letter from the IRS looks like it was drafted on a typewriter. These days, most HOAs are not going to qualify. They're simply not going to fulfill the requirements of a 501c4 and therefore are not going to be able to obtain that exemption. So if an HOA does not have that tax exemption letter, but says, we just know that we are a 501c4, I say, well, show me your Form 990. If the Form 990 says that you're a 501c4, then you may be exempt, depending on how long ago you filed that Form 990. So in the old days, when the tax laws were different, and by old days, I mean like over 10 years ago, by filing a Form 990 and identifying yourself as a 501c4, that might have sufficed. However, the tax laws have changed, and now if you self-designate as a 501c4, that is not going to be the end of the analysis for the IRS. They are then going to make you jump through a bunch of additional administrative hoops in order to attest to the fact and provide detail and verification that you are in fact a 501c4. If you're not able to provide that information to the IRS, you're not going to qualify for the exemption and you're going to have to submit the report. So who are an HOA's beneficial owners? According to the CTA, the beneficial owners are any individuals who directly or indirectly, through any contract arrangement, understanding, relationship, or otherwise, exercise substantial control over the entity or owner control 25% or more of the ownership interest of the entity. Now, as HOA board members, you don't own anything, but that first number one there, exercises substantial control. Well, it seems as though that is something that you probably likely do in your HOA. But the CTA goes one step further and they actually define what substantial control means. Substantial control means you serve as a senior officer of the company, have authority over the appointment or removal of senior officers, over the appointment or removal of a majority of the board, or you direct, determine, or have substantial influence over the important decisions of the company or have any other form of substantial control. Now, you don't have to meet all of these in order for you to be considered having substantial control over the entity. Any one or two will suffice. And as you know, as an HOA board member, you do have authority over the appointment and removal of officers and directors, maybe not directors. You may require a membership vote to remove, but you do have that exertion of control over the governance of the community. And so there is no doubt that you as an HOA board member are a beneficial owner of the corporation in accordance with the CTA. Management company, no. Anybody, and this is here as an example, people who or companies that serve as employees or agents of the HOA are not beneficial owners. The beneficial owners are the HOA board members. I also get the question oftentimes, is the architectural committee a beneficial owner? No. Architectural committee, any committee members are not beneficial owners. It is just the board. Whoever you would think when you file the articles of incorporation and you identify those three individuals on that document, it's the core individuals that run the community, the board. So what do you need to do now? If you have not already, you need to go get a FinCEN identifier number. And the FinCEN identifier number is not complicated. It's not hard to get. All board members need to get it, unless you were formed after January 1, 2024, in which case there's someone else also has to get a FinCEN number. But I'm assuming if you're on this call, then you're already formed. Your HOA is already well established, and so you don't need to worry about that one. But all board members, yes, need to go get a FinCEN identifier number. You have to go to this website here in order to get that FinCEN identifier number. And the number is kind of like your social security number or like your driver's license number. It is the same number that you will use from now until forever. It does not change. If you already have a FinCEN number by virtue of the fact that you are part of another corporation, it's the same number. You would just plug that same number into your reporting application. And so what you need to do in order to get that FinCEN number is you have to give your name, your date of birth, your residential address, and then you need to upload a copy of your driver's license or your passport. The entire process should take you no more than 5 to 10 minutes. It's pretty easy. And so once you give the information to the FinCEN, they will punch back to you an email confirmation and they will give you your very special individual number that you will use forevermore. So there are board members out there that have said, well, I don't want to get a FinCEN number. I want to stay on the board, but I don't want to have to be the one to do it. Management company, you do it, or someone else go do it for me. So if you want someone else to get the FinCEN number for you, then that's fine. You can do that. However, if you do that, what you're going to have to do in order to enable that person or company to get your FinCEN number is you're going to have to hand over your driver's license. You're going to have to hand over your all of your information with regard to your birth date and your residential address. And then what is scary a little bit about it is that if you produce that information, then technically that application that gets filed includes that copy of your driver's license and is subject to production pursuant to a records request by a homeowner, meaning homeowners could get access to your driver's license, which nobody wants to have happen. So the alternative is to just go get the FINSA number yourself, which is what I recommend. Disclaimer, I'm not your attorney unless I am your attorney, in which case, listen to what I'm telling you to do. But if I'm not your lawyer, check with your own lawyer. My recommendation is to get the FINSA number yourself and then give that to whoever is filing this application on the HOA's behalf. When you get your FINSA number, all you have to do is give the company who is filing your application that number. Boom, that's it. That number and your full legal name. And then when they complete that application, all they're putting in is your name and your FINSA number. They don't have to upload your driver's license. They don't have to give any information about you because all of that information is already tied to that FINSA number that is on file with FinCEN. So there are some many lawsuits that are out there right now. And there was a case earlier in the year that was a bit misleading because the CTA was held unconstitutional by a district court in Alabama. And the rumor started that, oh, the CTA is unconstitutional. We don't need to worry about it anymore. But no, that's not the case. That lawsuit was specific to the plaintiffs in that case. And according to FinCEN, who is very much on top of all communications in this with regard to the CTA, actually published a statement saying, hey, everyone still has to comply with the CTA. Don't think you don't because of that lawsuit. That only had to do with that lawsuit. And so an appeal has been filed. The court system, everything in the court system, as you know, if you've been involved in any kind of lawsuit, takes forever. And so although there is an appeal and it is active, these things take forever in the court system. And so the idea that this is going to be resolved before the end of the year, we don't need to worry about it, is very highly unlikely, especially now that we are almost in the second week of October. So FinCEN, so our HOA trade organization that operates out of the state, well, they operate nationwide, called CAI, had been advocating to FinCEN and requesting that FinCEN issue a moratorium, essentially a hold on the CTA requirements for HOAs in order to allow that case to play out so that we would know whether or not ultimately HOAs would even have to comply. To which FinCEN said, HOAs are not special, and unfortunately, you, just like everybody else, have got to comply with the CTA. And so they have an ongoing frequently asked questions section on their website that they update every couple of weeks, and they have actually published a statement about HOAs. So they know who we are, they know that we're not happy, and when ultimate decisions are made with regard to the constitutionality of the CTA, FinCEN and everyone else will be well aware that HOAs stand to either lose or gain from these requirements. Now, I have to tell you what the penalties are for noncompliance with the CTA, because there are those board members out there that said, forget it, I'm not doing it. I'm staying on this board, but I'm not going to comply. So what the penalties are is if you willfully provide false information or you fail to provide complete information, you can be subject to a fine of up to $10,000 and can be imprisoned for 2 years. Now, do I think that FinCEN is going to come after HOA board members who don't complete the beneficial owner reporting information? No, I don't. I think they have bigger fish to fry, and they have criminals that they actually are intending to pursue with this initiative, but it's still there. And I have to tell you what those penalties are. Now, you'll note that it says willful. So this is something that you have to do on purpose. You have to purposely fail to comply or purposely provide false information in order to be subject to these fines. And so if you aren't, because there are some HOAs out there that are self-managed, or they are not kind of in the know with regard to the laws and the regulations that affect HOAs. If they don't know about the CTA, how will they comply? If they're not sitting on one of these webinars or attending another education, they would have absolutely no idea. So the deadline is January 1, 2025, and that's the deadline to file your initial report. If you have formed between January 1, 2024 and January 1, 2025, you've got 90 days after you're created to file the paperwork. And after January 1, 2025, you've got 30 days in order to update and file with FinCEN. So there are ongoing obligations. You file that initial report January 1, 2025, but then anytime the beneficial owner information changes, you have to update FinCEN within 30 days of a change. So if you have an election and a couple of board members roll off, a couple more come on, well, then within 30 days of that change, you have to update FinCEN with the new board members' information. So this is going to apply to any change in the reporting company information, meaning that if you move and your driver's license is no longer accurate, or because it's got your old residential address and you've reported a different address, then technically you need to update FinCEN with your new address or your new driver's license. And this applies to any of the changes in your information. Obviously, your birthday isn't going to change, but your name could change if you get married or get divorced. And so if any of the information changes, you, according to the CTA, are obligated to update FinCEN with your new information. So HOAs have asked, well, what should we do? Should we do it now? Should we file now? Or should we wait till the end of the year? And what I have told everybody is wait until the fourth quarter, which here we are in the fourth quarter. And then to make sure that, because you only want to do this once, if you're going to have an election between now and the end of the year, then wait until after that election and then file the paperwork, because otherwise you'll have to do it twice. If you are a board member who is rolling off the board before January 1, 2025, none of this applies to you. If you are seeking re-election, this will apply to you if you get re-elected. So if you right now, anyone on the phone if you know that you're going to be a board member as of January 1, 2025, there's no reason to wait any longer. Get your FinCEN number and give it to the management company or whoever is filing this application on your behalf. There are a lot of lawsuits out there now, and CAI that I mentioned, they filed a lawsuit. There are lawsuits all over the country, and the reality is, again, as I mentioned, the court system takes forever. The reality is that if a decision on this issue between now and January 1, 2025 is highly unlikely. And so don't wait, just get it done.